Hi, Mr. Perez. I appreciate you coming, and in looking at this information, I'm very sorry to hear about this. Apparently, you have a guardianship over your younger brother because your parents are deceased, and your younger brother, who's under 18, has gotten involved with the law. Specifically, he's charged with a violation under our criminal laws, or a violation of an offense, which, if he was 18 or older, would be handled in either the municipal or criminal courts, depending upon the severity of it. You're my client because you have guardianship over this minor. Typically, I see clients who are parents that come in with their child, either together or a single parent. The child cannot contract with an attorney because they haven't reached the age of adulthood, 18. So, therefore, my client is you, even though I'm going to be doing my best to help your younger brother. Let me explain some things about juvenile matters that, over my 30 years of experience, I've handled with great success and great frequency. These are conducted not in the criminal part of the Superior Court, but in the family part of the Superior Court. And the reason for that is that there is an effort not to stigmatize children under the age of 18 with a criminal conviction or offense. All efforts are made to rehabilitate them. And when these matters are conducted in the family part, that's a private courtroom setting, not a public courtroom setting. Obviously, you will be allowed there, I will be there, your brother will be there, the minor, the court, and the court staff. Other than that, no one is going to know about this. It won't be in the papers. The only reason why anyone would know about it is if your brother, the minor, the juvenile, discusses it with other people. So I would suggest that you speak to him immediately and tell him to keep this confidential and not to discuss this with anyone other than me. Another example of how this is treated in the family part of Superior Court is not to use names such as defendants, not to use words such as conviction. Instead, your brother is a juvenile, and were there to be a disposition of his case by a finding of guilty, for example, it will not be a conviction. It wouldn't appear as a conviction. It would be called a disposition. He is entitled to all of the rights that any defendant has in a courtroom in our state, with the exception that this is a matter that's going to be heard solely by the judge and not by the jury. He's entitled to all of the protections of our Constitution. And the rules are different. The rules are designed to rehabilitate. And in some cases there is punishment, and that's where I may be of assistance, in addition to determining whether or not there's actually a defense to these juvenile complaints. But I look forward to hearing you about this more as we proceed in this case, and I appreciate you coming in to discuss it with me.
To begin the defense of your case, you can schedule an appointment with attorney Richard R. Uslan for a free consultation. Just call toll-free 24 hours a day, 866-433-3638. Leave a message after business hours. Remember, you are absolutely entitled to a defense of your case. Your defense can begin right now by calling attorney Richard R. Uslan.